Okay, good morning. Looking at community property where we left off on page 8. Part D, role of presumptions in determining character of property. Presumption that property acquired during marriage is community property. Property acquired during marriage is presumed to be community property. Estate of Duncan is a citation for that of 1937. Some cases say that possession during marriage is sufficient to raise a presumption that the asset is community property. But at least one case has required the community property proponent to demonstrate acquisition during marriage in order to raise the community property presumption. That's from Casualty and Company versus Mahoney, 1945. Exception at death when divorce occurred more than 4 years earlier. The presumption that property acquired during marriage is community property does not apply to property held by a person at the time of death if the person during which the property was acquired ended by divorce more than 4 years prior to death. B, overcoming community presumption when asset acquired during marriage. The community property proponent may overcome the community property presumption by showing any of the following facts. Statutory facts. 1. Even though the asset was acquired during marriage, it satisfies the statutory definition of separate property because Romanet 1, it was acquired by gift, bequest, devise, or descent, or Romanet 2, it was the rent or income of separate property. California Family Code, Section 770. 2, parties agreed property would not be community property. The community property presumption is overcome if the parties by agreement before or during marriage agreed that the property would not be community property. 3, parties took inconsistent written joint title. When both spouses knowingly take written title to an asset in a manner that shows that the parties agree to hold it jointly in a form other than as community property, for example, joint tenancy or tenancy in common, the community property presumption is overcome. Having agreed to a certain form of title, the parties can alter that form of title only by subsequent agreement. In Lucas versus Lucas, by contrast, title is one spouse's name, and one spouse's name alone does not on its face evidence any agreement between both spouses. So this is pretty much all getting highlighted, especially because it's an area where I've been confused in the past. So there's a community property presumption for all assets acquired during marriage, but if the title does what? Is written in a manner that shows that the parties agree to hold it jointly in a form other than community property, such as joint tenancy or tenancy in common, the community property presumption is overcome. Title in form that evidences gift to the other spouse. The community presumption may be overcome if one spouse takes title in a manner that evidences a gift of her community property interest to the other spouse. For example, a husband might overcome the community property presumption by showing that his wife bought him a sports car for his birthday and placed title in his name as his separate property. Marriage of Frappo. A spouse cannot make a gift to himself of the other spouse's interest in community property. Thus, when a purchasing spouse takes title in his own name alone, it does not refute the presumption that the asset is community property. Title in the purchasing spouse's name alone is, however, consistent with tracing an asset in whole or in part to a separate property source. See below. In order to refute the community property presumption that arises from acquisition of the asset during marriage. Thus, when title is taken in a purchasing spouse's name alone, he is allowed to trace to a separate property source in order to establish a separate property interest in the asset. So again, it's like taking title that inures a gift. Title in a form that evidences gift to the other spouse. That'll overcome the presumption too. You're going to move to page 10 in just a second. Tracing purchase funds to separate property source. In certain circumstances, a spouse may overcome the community property presumption by tracing purchase funds to a separate property source. In such case, the separate estate is a proportional owner to the extent of its contribution to the purchase price. Husband, in your example, husband purchased an antique chair during marriage. He paid $2,000 and can prove he paid $1,000 of the purchase price from separate property source. Husband separate property estate has a 50% ownership interest in the chair. By virtue of the presumption that property acquired during marriage is community property, the community estate has the remaining 50% ownership interest in the chair. If at divorce a chair is sold for $20,000, each estate is entitled to $10,000. Tracing for the purpose of establishing an ownership interest is permissible only when, one, an asset is untitled, or two, the form of title or other evidence does not show that the parties agreed to the same or other form of ownership. One property is titled as joint tenancy. For example, merely tracing separate property or community property purchase funds would fail to address the implication drawn from the form of title. For example, taking title and joint tenancy, the spouses agreed that they would equally own the asset, and the surviving spouse would own a 100% interest in the asset. Stated differently, in an inconsistent form of title may trump tracing for the purposes of establishing an ownership claim. Separate property contributions to the purchase price of an asset may be reimbursed, but the separate property contribution does not affect ownership of the asset. All right, section E, agreements that alter character of the property. Parties may entirely or partially avoid the California community property system of agreement. By agreement, according to California Family Code 1500, it is necessary to distinguish premarital anti-nuptial contracts from agreements made during marriage, because the two types of contracts are regulated by different rules. Agreements made by parties during marriage, typically parties may make a prenuptial anti-nuptial separation of property contract, specifying that after marriage, each party's earnings will remain separate property, and that neither will take any intestate or other statutory death claims against the other's estate in marriage of Dolly. Premarital agreements are regulated by California's modified version of the Uniform Premarital Agreement Act, and that comes from section 1600 to 1617 of the California Family Code. A, no consideration required. A premarital agreement does not require any consideration according to 1611. The statute of frauds requirement, California law has long included premarital agreements within the statute of frauds. There must be a writing signed by both parties. As with most contracts subject to statute of frauds, there are exceptions. An oral premarital agreement may be enforced when, one, the promise has been fully executed, performed by the promisor, or two, the promisor is stopped to assert the statute of frauds. A promisor is when the promisee has relied to her detriment on the oral premarital agreement. However, marriage alone does not raise an estoppel. May regulate property rights and spousal support obligations. When premarital agreement provisions limiting property rights and those limiting the parties' spousal support obligations to each other are both enforceable, provisions limiting support obligations are subject to a higher level of judicial scrutiny. D. Circumstances that render premarital agreements unenforceable. Premarital agreements will not enforce if they promote divorce. Only those terms that create a positive incentive for one party to seek a divorce are unenforceable. So it'll just strike that section apparently. And that comes from the Marriage of Dolly. Agreement executed involuntarily. A premarital agreement is not enforceable if the party against whom enforcement is sought did not execute it voluntarily. From section 1615A1, an agreement is not executed voluntarily unless the courts find all of the following. This is a 5-part test. Remember this test. I even remember the Dolly case. Executed voluntarily. What is voluntarily? The party against whom enforcement is sought was represented by an independent counsel when she signed the agreement, or after being advised to seek independent counsel, expressly waived, and such representation in a separate writing. At least 7 days before it was signed, the agreement was presented to the party against whom enforcement is sought, and that party was advised to seek independent counsel. Note, this is not an absolute 7-day waiting period. It is intended to give a party the opportunity to seek legal counsel. If a party is represented by independent counsel from the outset of negotiations and multiple drafts of the document are exchanged, a failure to wait 7 days between presentation of the final version and signing does not render that agreement unenforceable. See Marriage of Caldwell Faso and Faso. Third, if represented by legal counsel, the party against whom enforcement was sought was fully informed in writing to the signing of the agreement of the terms of the agreement and the rights she was giving up by signing the agreement, and was proficient in the language of the explanation of the agreement. Fourth, the agreement and other required writings were not executed under duress, fraud, or undue influence. And fifth, any other factors the court deems relevant. That's all from 1615 California Code. Unconscionability coupled with non-disclosure. A premarital agreement is not enforceable if the party against whom enforcement is sought proves that Romanet 1, it was unconscionable when executed, and Romanet 2, the party did not and could not have had adequate knowledge of the wealth of the other party and did not waive her right to disclosure of such wealth. Yeah. So adequate knowledge of wealth. You kind of need to render some financials to the person you're about to marry if you're going to have them sign, like, give informed consent or whatever, knowingly sign a premarital agreement. Certain spousal support waivers. A premarital agreement provision regarding spousal support is not enforceable if the party against whom enforcement is sought was not represented by independent counsel, or enforcement of the provision would be unconscionable at the time of enforcement. An otherwise unenforceable provision does not become enforceable solely because the party against whom enforcement sought was represented by independent counsel. Waiver of death rights must satisfy family code or probate code. To be enforceable, a premarital waiver of marital death rights, a spouse's right to receive property or benefits from the other spouse's estate, must satisfy the requirements of either the family code or the probate code. The family code requirements are discussed above. Premarital agreement that does not satisfy the family code may nevertheless be independently enforceable as a waiver of inheritance rights under the probate code, estate of will. Similarly, a waiver of death rights that does not satisfy the probate code may be enforceable if it meets the family code requirements, estate of Gagnier. Wife's premarital waiver of death rights upheld despite failing to meet probate code requirements of representation by counsel because it satisfied the then weaker family code requirements. Agreements during marriage to alter the character of the property, transmutation. So this is like, I don't know if they're talking about transmutation as it may exist in a premarital agreement, but it seems to me like we just exited premarital agreement section. I mean, ultimately, we're in agreements that alter character of property. So we started with 1, premarital agreements, and now we're 2, talking about transmutation, which they're referring to as agreements, and why we'll see is because it requires writing. During marriage, the spouses may, by transfer agreement, change the status of any and all property from separate to community, from community to separate, from one spouse is separate to the other spouse is separate. These changes are called transmutation. So that's your definition. Requirements for a valid transmutation. To be valid, a transmutation must be made in a writing, written express declaration that is consented to or accepted by the spouse whose interest is adversely affected. The writing must expressly declare that a change in the ownership of property is being made. Extrinsic evidence is not admissible to interpret the meaning of the writing. I'm just going to call this one element present interest. I'm going to call these elements. I mean, honestly, it needs to be 1, written express, 2, consented by the spouse whose interest is being adversely affected. I'm going to say 3 words of present interest, intent, I mean. And what's the last thing here? Well, I think I just said that. And then this comes from the state of McDonald. Extrinsic evidence, right. Extrinsic evidence is not admissible to interpret the meaning of a writing. There are no exceptions to the writing requirement. The common law exceptions by ordinary statutes to frauds are available. Let's see if that McDonald case. Okay. There's also a marriage of Benson listed here. Here's an example. Has to do with a widower claimed that his deceased wife had relinquished her community property interest in his IRA when she signed a required bank form that gave her consent to his designation of a trust as the beneficiary of the IRA. The California Supreme Court held that she retained her community property interest in the IRA funds because it was not possible to tell from the face of the document whether the decedent wife was aware that the legal effect of her signature might be to alter the ownership or interest of her interest in the pension funds. The court stated that the addition of words such as hereby giving up any interest I may have would have made the wife's signed consent a valid transmutation. Breach of the transmutation requirements. The transmutation requirements apply to the property already owned by the parties. They also apply to the purchase by one or both spouses when the form of title is inconsistent with the character of the purchase price, marriage of valley. Note the property titled in a married person's name alone may be either community property or that person's separate property. Title alone does not specify whether it is community or separate property, nor does the title indicate that a party intended to give up any interest he might have in the property. Example, I like examples that are actual cases. Husband purchased a life insurance policy on his life with community property funds and named wife as the owner as well as beneficiary of the policy. The policy was community property because the transmutation requirements were not satisfied. Husband never expressly declared that he gave up any interest that he might have in the policy. As noted above, the fact that title was held in wife's name alone is inherently ambiguous. Exception for personal gifts of relatively insubstantial value. The writing requirement does not extend to gifts between the spouses of items of a personal nature, including clothing and jewelry, that are used primarily by the spouse to whom the gift is made and that are insubstantial in value, taking into account the financial circumstances of the marriage. Section 852 of the Family Code, California Family Code, and marriage of Buey and neighbors. Porsche automobile is not article of personal nature. B, transmutation agreements subject to fraudulent transfer of law. Although a marital agreement transmutation, transmuting a spouse's future earnings may be effective as between the spouses. It remains subject to the law regarding fraudulent transfers. After a wife noted that the state would seek to reach her future community property earnings to satisfy her husband's tax debt, the wife and husband entered an agreement transmuting the wife's future earnings into her separate property. The transmutation was a fraudulent transfer and therefore did not prevent the state from reaching the wife's future earnings. State Board of Equalization versus Wu. Statements in will not admissible. A statement in a will as to the character of property is not admissible as evidence of the transmutation of the property in any proceeding commenced before the death of the testator. In other words, a person seeking a divorce is not bound by the characterization of property in his will. Inter vivos trusts must contain unambiguous indication of transmutation. It's crazy that a trust matters, but a will doesn't. So a will cannot transmutate, but a trust possibly can. Inadmissible, like as evidence of transmutation of a property. Okay. Well, you get it how you get it. I understand. Inter vivos trusts. Unlike a will, which has no effect on the property ownership until the testator dies, transfer of property into an inter vivos trust normally has immediate ownership effect. Nevertheless, as between living spouses, a revocable living trust provision stating that all property not identified as separate property of the spouses is their community property. Does not work at transmutation under Section 853 because there is no unambiguous indication that one spouse hereby presently intended to change the character of the separate property he placed into the trust. A statement about the character of property in a living trust created To avoid probate is generally intended by the settlor to be effective at his death. Absent unambiguous indication otherwise, it should not be interpreted to work immediate transmutation. In re Marriage of Starkman. Presumption of undue influence may upset formally adequate transmutation. In transactions between themselves, spouses are subject to the fiduciary rules that govern confidential relationships, Section 721 of the California Family Code. The confidential relationship of spouses is like a fiduciary relationship. The confidential relationship of spouses imposes a duty of the highest good faith and fair dealing of each spouse. A rebutable presumption of undue influence arises when one spouse gains an advantage over the other in a property transaction. A spouse who obtained the advantage bears the burden of rebuting the presumption. Thus, if a disadvantaged party contests a transmutation or other interspousal transaction, the advantaged party bears the burden of proving that the disadvantaged party freely and voluntarily consummated the transaction, with full knowledge of all the facts and complete understanding of the effect of the transaction. Marriage versus Haynes. Agreements to change the character of property inferred from title. This is Section F. People may take written title to property in a form that is inconsistent with the character of funds used to purchase the property. For example, a husband may take separate property funds and purchase a family vacation home and that he titles as joint tenancy or community property as a collateral matter. California community property law infers an intent to change the character of the property to the form evidenced by an unambiguous written title that clearly states the form in which the property is held. Note that we respect the transmutor's intent only when he had legal power to effectuate his intent. Thus, we do not allow one spouse alone to transmute community property to his own separate property because he has no power to do so. Ways a married couple may jointly hold property. In California, a married couple may jointly hold property in joint tenancy as tenants in common, as community property, or as community property with the right of survivorship, according to 750 and of the Family Code and 682 of the Civil Code. This fourth form of title effectively grafts the joint tenancy right of survivorship onto community property title. Married couple may also hold partnership interests according to Civil Code 684, but this form of ownership presents no special community property issue. These forms of ownership are mutually exclusive. Joint tenancy. A right of survivorship. When one tenant dies, the survivor takes title to the entire property. When spouses hold property as joint tenants, each spouse owns an undivided one-half interest, and each one-half interest is separate property. This right of survivorship distinguishes a joint tenancy from a tenancy in common and from ordinary community property. A joint tenancy can be created only by explicit language. G to John Smith and Mary Smith as joint tenants, or G to John Smith and Mary Smith as joint tenants with a right of survivorship. It's from the Civil Code 683. Okay. Not really any different than what you learn in co-tenancies. Survivor takes the title to the entire property when one of them dies. When they hold as joint tenants, each spouse owns an undivided one-half interest, and each one-half interest is separate property. This right of survivorship distinguishes from a joint tenancy from a tenancy in common and from ordinary community property. A joint tenancy can be created only by explicit language. Got it. Tenancy in common. Unless otherwise indicated, tenants in common possess equal proportional ownership interest in the asset. There is no right of survivorship. A deceased co-tenant's interest passes by his will, or if he leaves none, to his intestate heirs. A tenancy in common may be expressly created by a grant to spouses. For example, G to John Smith and Mary Smith as tenants in common. A tenancy in common may also be created by a grant that is not sufficient to create joint tenancy or community property. Tenancy in common is effectively a residual, catch-all form of common law property ownership. Community property. Only married persons and registered domestic partners may hold title as community property. Community property is a form of title in which each spouse owns an undivided one-half interest, and neither spouse can partition the whole. Neither spouse may appropriate one-half of his separate property as a separate property. A finding that property is held as community property has various ramifications, particularly at death. Title is explicitly taken in community property when the parties are identified as spouses or when community property title is specified. Family Code Section 803. The following grants create community property. G to John Smith and Mary Smith, husband and wife. And John Smith and Mary Smith is community property. Community property with right of survivorship. Married couples and registered domestic partners may also take title as community property with the right of survivorship. To do so, they must expressly declare this form of title in a document of transfer and may sign or initial the document to indicate their assent to the form of title. Note that during the ongoing marriage and at divorce, the property is treated as community property. It is only at death, and there is no difference between community property with right of survivorship and community property without a right of survivorship. Prior to the death of either spouse, the right of survivorship may be terminated in a manner as a joint tenancy may be severed. If the right of survivorship has not been terminated prior to the death of a spouse, then the decedent's interest vests in the survivor as a joint tenancy vests in a surviving spouse. All jointly held, that's from 682 of the Civil Code. So everything is the same with community property up until death. I think it's obvious what happens after death. Even though it doesn't say it specifically, I do believe that would be separate property. Anyway, all jointly titled property presumed community property at divorce. All property held by the spouses in joint form is presumed to be community property for purposes of distribution at divorce or legal separation. Legal separation is a rarely used variant of divorce. A judicial decree of legal separation terminates many of the incidents of marriage, but does not change the status of the parties from married to unmarried. Thus, they cannot remarry. This includes property held in joint tenancy, tenancy in common, community property, community property with right of survivorship, and tenancy by the entirety. The presumption that such property is community property at divorce may be overcome only by a collateral written statement or a statement in the documentary evidence of title that the property is separate property and not community property. So let's just read an example. H and W bought a house for $100,000 cash, $70,000 of community property funds and $30,000 of wife's separate property funds. Title was taken in joint tenancy. H and W decided to divorce, and W claims a 30% separate property ownership in the appreciated home based on the 30% separate property contribution to the purchase price. W may overcome the presumption that the home is community property only by showing a written agreement between the parties that she would maintain a separate property ownership interest. That's crazy. Because the title was what? It doesn't even say how they took the title. Like, this is an inappropriate example. I'm thinking they would need an agreement. Would they? Okay, they would need an agreement, regardless of what they put, what title they put it in. I mean, if they put it in like community property with right of survivorship or something, and she intended to keep her 30% as separate property, then yeah, I can see an agreement. Without that, I don't think I can see why. I thought the title could rebuke the presumption it was community property. Reimbursement. If the joint titled property is Section 2581 community property, because there is no writing to the contrary, at divorce, any separate property contributions to the acquisition of the property are reimbursed to the separate property contributor without interest or appreciation. This is different. Contributions to the acquisition. Okay. If a jointly titled property is Section 2581 community property, because there is no writing to the contrary, at divorce, any separate property contributions to the acquisition of the property are reimbursed to the separate property contributor without interest or appreciation. Contributions to the acquisition of property include the application of separate property to pay the purchase price to reduce the principal of a loan used to finance the purchase, but do not include interest payments on the loan or payments made for maintenance, insurance, or taxation of the property. Section 2640 of the Family Code applies to improvement of community property. The same right of reimbursement applies to separate property funds used to improve community property. Spouse deeds separate property into joint title. When a spouse deeds separate property into joint title, Section 251 property, the Section 2640 contribution to the acquisition of the property is the fair market value of the property at the time it was deeded into joint title. Marriage of Hikes. There is, of course, some tension between this interpretation of 2640 and the transmutation provisions, which explicitly permit spouses to transmute separate property of either spouse into community property and to transmute separate property of one spouse to separate property of the other spouse. And tracing separate property contributions through successive purchases, a spouse may seek Section 2640 reimbursement from the asset initially purchased with separate property contributions, and also from any community property assets subsequently acquired from funds derived from the initial asset. This comes from Marriage of Walrath. I like that holding, honestly, better than I like any of the sections above it. Sections 2581 and 2640 do not apply at the death of a spouse. When marriage is terminated by death of the spouse, the former title controls. If title is held in joint tenancy, the surviving spouse takes the entire asset by virtue of the joint tenancy right of survivorship. If title is held in joint and equal form and one spouse has contributed separate property funds to the purchase or improvement of the property, contribution is presumed to be a gift, absent an agreement of the parties to the contrary. There is no right of reimbursement unless the parties have so agreed. See Marriage of Lucas. Section F here, Section G here. It's not long, so we're going to do tracing. Property purchased from commingled funds. Probably stop in one page. Frequently, one or both spouses commingle community and separate funds in a single account. At divorce or death, the owner of separate funds may attempt to trace these funds to claim a separate property interest in the funds or in an asset that was purchased with the funds. Two important presumptions for tracing funds in a commingled asset: family expenses paid by community funds. Available community funds are presumed to have been used to pay for family expenses. Thus, separate funds are deemed to have been used to meet family expenses only when community funds are exhausted. Gift presumed when separate funds used to pay family expenses. When separate funds are in fact used to pay family expenses, a gift to the community is presumed. In other words, the separate estate has no right of reimbursement when community funds are later deposited. The presumption of gift can be overcome by evidence of reimbursement agreements. See verse C. Two permissible tracing methods is your exhaustion method and direct tracing. The exhaustion method, the separate property proponent may show that at the time he purchased the asset whose character is contested, the community funds in the account had already been exhausted by family expenses. Therefore, the asset must have been purchased with separate funds. Estate of Nielsen. Direct tracing. Alternatively, the separate property proponent may show that at the time the asset was purchased, 1, there was sufficient separate as well as community funds available, and 2, he intended to mix those separate funds to purchase a separate property asset. Marriage of mix, LOL. All right. Separate property proponent may not use recapitulative accounting. The separate property proponent may not simply show that total family expenses during marriage exceeded total community income during marriage and conclude, therefore, that all remaining funds and assets purchased from the commingled account are a separate property. This method would run afoul of the second tracing presumption. To trace the separate property proponent must actually establish a chronological schedule. Effect of failure to trace entire account treated as community property. If the separate property proponent cannot or does not perform one of the two permissible methods of tracing, the entire commingled account and the assets purchased from this account will be treated as community property. This is consistent with the general community property presumption that arises from acquisition during marriage, estate of Murphy. And last, when commingled bank account is jointly titled, Probate Code 5305 specifically controls jointly titled commingled bank accounts. Section 5305 effectively refuses to make any gift presumption from the bank account form of title. Instead, it allows full tracing of separate funds, subject to the tracing above, unless the parties have agreed otherwise. So that's where we're going to leave